Okay, Chapter 4, Scope of the Exclusionary Rule. In many cases, the police obtain evidence as a direct or primary result of an illegal arrest, search, or seizure. For example, the police find drugs as a result of an illegal search, and those drugs are suppressed pursuant to the exclusionary rule. See Supra Chapter 3. Often, however, the police will also obtain evidence that is secondary or derivative in character. For example, the police may illegally arrest someone and then later obtain a confession from the suspect at the station house. That confession, in turn, may direct them to important physical evidence. That is, when is that secondary or derivative evidence tainted by the prior constitutional violation? Or, to use the phrase coined by Justice Frankfurter in Nardone v. U.S. 1939, when is the secondary or derivative evidence a fruit of the poisonous tree? The first case in this section, Wong Sun v. U.S., answers this question by explaining that much of the fruit of the poisonous tree analysis can be likened to causation inquiries. First, there is a question whether, but for the illegal activity in questions, the government would have discovered the evidence. Whether, but for the illegal action in government, would have discovered the evidence. The exclusionary rule has no application when the government learned all the evidence from an independent source. This means that if the Fourth Amendment violation is not the cause and fact of the police discovering the challenged evidence, that evidence is not a fruit of the prior violation. The violation of the person's rights does not put him beyond the law's reach if his guilt can be established by evidence connected with or untainted by the violation. A variation of the independent source exception is the inevitable discovery or hypothetical independent source rule. This doctrine differs from the independent source exception in that the question is not whether the police actually acquired certain evidence by reliance upon an untainted source, but whether evidence in fact obtained illegally would inevitably or eventually have probably have been discovered lawfully. If so, then it is not the police illegality in question that in fact caused the police to discover the evidence. They would have discovered it anyway. In addition to these two but for causation inquiries, there is also approximate causation analysis under the fruit of the poisonous tree doctrine. The discovery of evidence can become so attenuated in time, place, and circumstances from the initial Fourth Amendment violation as to dissipate and taint the result in the admission of the evidence. After the Wong Sun case lays out the basic framework for analyzing the admissibility of derivative fruits, the subsequent cases further explain the proximate and but-for causation inquiries. The Brown v. Illinois, New York v. Harris and Utah v. Strife cases examine how the Supreme Court has developed the proximate cause part of the fruits inquiry. Murray v. U.S., Nix v. Williams, and Hudson v. Michigan then explore the cause and fact but for prong of the analysis and focus on the independent source and inevitable discovery doctrines. Part 1, Introduction. Wong Sun v. United States, 1963. Justice Brennan delivered the opinion of the court. 6 federal narcotics agents illegally broke into Toy's laundry and arrested him for violating federal narcotics laws. Toy then told the agents that Yee had been selling narcotics and that he and Yee had smoked some the night before. The agents immediately went to Yee's house, entered, and found Yee, who surrendered heroin to them and gave a statement implicating Toy and the third party, Wong Sun, in narcotics trafficking. Agents entered Wong Sun's home and arrested him. Toy, Yee, and Young Sun were all arraigned before a commissioner on narcotics charges and released on their own recognizance. A few days later, they came to the office of the Narcotics Bureau, where agents interrogated them after informing them of their right to withhold inculpatory information and to seek the advice of counsel. All three of them gave incriminating statements. At Toy and Young Son's later trial, Yi was called as the government principal witness, but he was excused after he invoked his privilege against self-incrimination and repudiated the statement that he had given. Instead, the government relied on statements Toy made in his home at the time of the arrest at the narcotics surrendered by Yi. Toy's later statement at the Office of the Narcotics Bureau and Wang Sun's statement at the Office of the Narcotics Bureau. Toy and Young Sun objected that all four pieces of evidence were inadmissible fruits of unlawful arrests and searches. A trial court denied their suppression motion, and they were both convicted of violating federal narcotics laws. The Ninth Circuit, although recognizing both petitioners' arrests were illegal because not based on probable cause, affirmed. We agree with the Ninth Circuit that there was not probable cause to support Toy's arrest. The exclusionary rule extends as well to the indirect as the direct products of Fourth Amendment violations. Mr. Justice Holmes, speaking for the court in Silverthorne Lumber Co. v. U.S., 1920, in holding that the government might not make use of information obtained during an unlawful search to subpoena from the victims the very documents illegally viewed, expressed succinctly the policy of the broad exclusionary rule. Quoting, the essence of a provision forbidding the acquisition of evidence in a certain way is that merely evidence so acquired shall not be used before a court, but that it shall not be used at all. Of course, this does not mean that the facts thus obtained becomes sacred and inaccessible. If knowledge of them is gained from an independent source, they may be proved like any others, but the knowledge gained by the government's own wrong cannot be used by it in the way proposed. The exclusionary rule has traditionally barred from trial physical, tangible materials obtained either during or as a direct result of an unlawful invasion. The policies underlying the exclusionary rule do not invite any logical distinction between physical and verbal evidence, either in terms of deterring lawless conduct by federal officers or of closing the doors of the federal courts to any use of evidence unconstitutionally obtained. The danger to warrant introducing such a The danger in relaxing exclusionary rules in the case of verbal evidence would seem too great to warrant introducing such a distinction. The government argues that Toy's statements to the officers in his bedroom were admissible because they resulted from an intervening independent act of free will. This contention, however, takes insufficient account of the circumstances. 6 or 7 officers had broken the door and followed on Toy's heels into the bedroom where his wife and child were sleeping. They had been almost immediately handcuffed and arrested. Under such circumstances, it is unreasonable to infer that Toy's response was sufficiently an act of free will to purge the primary taint of the unlawful invasion. With respect to the drugs found at Yi's house, the government candidly told the trial court that we wouldn't have found those drugs except that Mr. Toy helped us to. Hence, this is not the case envisioned by this court in Silverthorne Lumber Co., where the exclusionary rule has no application because the government learned of the evidence from an independent source, nor is this the case in which the connection between the lawless conduct of the police and the discovery of the challenged evidence has become so attenuated as to dissipate the taint. Nardone v. U.S., 1939. We need not hold that all evidence is fruit of the poisonous tree simply because it would not have come to light but for the illegal actions of the police. Rather, the more apt question in such a case is whether granting establishment of the primary illegality, the evidence to which instant objection is made has been come at by exploitation of the illegality, or instead by means sufficiently distinguishable to be purged of the primary taint. McGuire, Evidence of Guilt, 1959, is apparently a quotation for that. We think it clear that the narcotics were come at by the exploitation of that illegality, and hence that they may not be used against Toy. So that's kind of their holding, I think. There's some bracketed text. Having determined that Toy's statement in his home and the narcotics found in Yee's house were inadmissible against Toy, the court found it unnecessary to determine whether Toy's later statement at the Narcotics Bureau was the fruit of his illegal arrest because it held, based on evidentiary principles, that A, Wong Sun's statement was inadmissible against Toy, and B, Toy's statement standing alone was not sufficient evidence to support his conviction. With respect to Wong Sun, the court also agreed with the Ninth Circuit that his arrest was illegally made without probable cause, but it held that no evidentiary consequences turned upon that question. For Wong Sun's confession was not the fruit of that arrest and was therefore properly admitted at trial. On the evidence that Wong Sun had been released on his own recognizance after a lawful arraignment and had returned voluntarily several days later to make a statement, we hold that the connection between the arrest and the statements had become so attenuated as to dissipate the taint. As for the narcotics surrendered by Yee, that this ounce of heroin was inadmissible against Toy does not compel a like result with respect to Wong Sun. The exclusion of the narcotics as to Toy was required solely by their taint of impropriety to information unlawfully obtained from Toy, and not by any official impropriety connected with their surrender by Yee. The seizure of the heroin invaded no right of privacy of persons or premises which would entitle Wong Sun to object to its use at his trial. Even though Wong Sun's statement at the Narcotics Bureau and the narcotics found at Yee's house were admissible against Wong Sun, the Supreme Court reversed his conviction because it could not be sure that the trial court had not improperly considered Toy's statements, which were inadmissible against Wong Sun, based on evidentiary rules when determining Wong Sun's guilt.